Hello friends. Today we will discuss a very important topic on multilateral instruments which is going to be effective from 1st April 2020. Friends, please note that don't forget to subscribe my channel so that you can get all updated on tax. MLI is an outcome of WEB's Action Plan 15 of the OECD Inclusive Framework. It offers solutions for government to plug in the loopholes in the international tax treaties. MLI allows the government to modify the application of the network of bilateral tax treaties without having to renegotiate each of the treaties separately. MLI will not replace the existing DTA. It will apply alongside the existing agreement which either supplement, complement, supersede, modify the existing agreement. This is in order to be in line with the measures set out to address BEPS. MLI will apply only those countries who have signed the MLI, ratified it in accordance with domestic law where such ratification, acceptance or approval is required, and deposited such instrument of ratification with the OECD depository and 3 months have passed from the date instrument of ratification have been deposited with the depository, thereby bringing the MLI into force. As of November 2019, 92 jurisdictions have signed and the MLI. Of those, 37 jurisdictions have deposited their ratification with the OECD. MLI will apply to only those tax treaties where both the parties to the treaty have conveyed the intention by notification to the covered by the MLI. Such treaties are referred to as covered tax agreements. For the specified bilateral tax treaties, MLI would have effect after both parties to a CTA have deposited their ratification instruments, which the OECD Secretariat. India deposited the document of ratification with the OECD on 25th June 2019. MLI provisions to enter into effect for 23 Indian bilateral treaties. Hence, for all cover tax agreements with India, MLI would come to force from 1st October 2019. MLI would come into effect from 1st April 2020. In relation to all the tax treaties India has with other countries, MLI will come into effect from 1st April 2020 for WST and other taxes. MLI will not impact India-USA treaty as USA is not party to MLI. MLI will also not impact India, China, Germany, Mauritius, Thailand, Brazil, Oman, since Indian tax treaties are not notified by the said treaties. India and China have recently amended its tax treaties through protocol signed on 26 November 2018. Among other, protocol incorporates changes required to implement treaty-related minimum standards against under BEPS project. A CTA will have to be required to meet certain minimum standards under BEPS. MLI has totally 39 articles, out of which the below are the minimum standards and have to be followed with no option. Prevention of treaty abuse, BEPS, which is part of BEPS Action Plan 6 and 7 of MLI. Dispute resolution more effective, which is part of BEPS Action Plan 14 and 16. Following country have released their synthesized text of tax treaties with India, which are UAE, Singapore, UK, Austria, Ireland, Japan, Finland, Serbia, Poland, and Slovak Republic. We will just see an example of how it impacts a particular DTA where MLI is entered. We just take the example of India and Singapore, which is effective from 1st April 2020. The impact will be to include Article 6 of the MLI, intending to eliminate double taxation with respect to the taxes covered by this agreement without claiming opportunities for non-taxation or reduced taxation through tax evasion or avoidance, including through treaty swapping arrangements aimed at obtaining reliefs provided in the agreement for the indirect benefit of residents of third jurisdiction. Article 7 of the MLI will apply prevention of treaty abuse. Notwithstanding any provision of the agreement, a benefit under the agreement shall not be granted in respect of an item because an item of income if it is reasonable to conclude having regard to all relevant facts and circumstances that obtaining that belief was one of the principal purpose of any arrangement or transaction that resulted directly or indirectly in that benefit, unless it is established that granting that benefit in these circumstances would be in accordance with the object and purpose of the relevant provision of the agreement. I hope I am able to provide you a broad view on the new provision of multilateral instrument, which is called MLI. For more information, call us at 90089440082 or email us at taxacharya@gmail.com. And please don't forget to subscribe our channel. Thank you.